Hey everyone, Harry here to talk about today's big oral argument in the DC Circuit on the Trump immunity motion. Let's see. Trump himself attends. He is at his counsel's elbow. His counsel, I think, generally makes a few blunders, but one of them is about polls and how Trump is ahead everywhere, with Trump nodding vociferously. So a little bit playing to the client. In general, Trump's lawyer had a pretty hard time. It went an hour plus, and he was questioned for almost 50 minutes, whereas the counsel for the government was questioned for 25. All right, but he took a very odd line. I think it was a terrible blunder. But what he wanted to say is that the Constitution gives immunity for criminal conduct by a president as an official act, leaving to the side, let's say, what I've called Fifth Avenue liability, save only if the president has been impeached and convicted, because the impeachment judgment clause says if you're impeached and convicted, you could still be tried. And, it seems patently obvious that it's a non sequitur to say that means if you haven't been, if you've been impeached but not convicted, as is the case with him twice, that you cannot be tried. So it seems like a proposed rule of law that they just seized onto under the facts. But, it doesn't make a lot of sense. It certainly doesn't say that you can't be impeached or been tried. And it just a moment's reflection. This involves the impeachment clause applies to anyone who's impeached, including people who have been convicted and tried without having been impeached, but higher officials. It's also the case there's all kinds of reasons why people aren't impeached, including that you could resign, as the DOJ made clear. So this means he could just, in his official duties, kill a rival and then resign, and therefore he'd be immune from criminal process. In general, it looked pretty weak. And then a new judge and a Biden appointee, Judge Florence Pan, came around and just basically put him on life support. She says, okay, so you're saying that if he orders a Seal 6, something that only the president can do to assassinate his political rival, that there would be immunity for that, yes or no? And Trump's lawyer here made two bad mistakes, it seems to me. One, in the moment, he just humfered and fumfered and wouldn't say yes or no. His answer that he wanted to say was, yeah, that's my position. It's a lousy position, but that was the position he wanted to have, only if there's been an impeachment and a conviction, and then just having taken the line in the first place. But he was sort of a dead man walking at that point in the oral argument, it seems to me. So the top line, and it's an important line, this claim has been kind of rumbling around like a vampire for years, and this will put the stake through the heart of it. He's going to lose the claim that he's immune. So that's the top line. I don't think it's particularly dramatic. I think it'll happen pretty quickly. They may already be writing, but I would say as soon as this Friday, and probably no later than a week after that. So that's all. That's the headline. It's a good headline. The sub-paragraphs, though, strike me anyway as a little bit trickier. So 3 judges here, 2 Biden appointees and 1 appointee of George H.W. Bush, George W. Bush's dad. So back in the 80s or 90s, Judge Henderson. And she, too, wasn't having any of the immunity argument, but she was. All 3 of them really were kind of probing and trying to figure out the right line. They took very seriously this immunity, no jurisdiction to take an interlocutory appeal, that is an appeal before the trial has gone forward, on immunity, because it's not an express constitutional provision, and there's a unanimous Supreme Court opinion there. There was fair discussion, and they hit both the lawyers out of the box with it. The lawyers both said, no, we don't want to argue that. but jurisdiction is something important, and the court has to satisfy itself of that, whatever the advocates say. So that seemed in play, and yet it kind of petered out a little bit into each argument, and it also seemed as if that wouldn't be the final response. But there definitely, and interesting things, there are people out there, if you read them, saying very different things. But then also there was some probing about the distinction, say, between, and this comes up in the civil context, between being an office holder and being a candidate. So if you apply some of the things they've said in civil cases, it might matter that Trump on January 6th is a candidate. He's not, this is not the State of the Union. And so, in that sense, maybe immunity is foreclosed. There was a lot of talk about Marbury versus Madison. Anyone who's ever gone to law school knows that's the most important case ever and the fountainhead of judicial review. But, it doesn't normally decide cases in the 21st century. But the question about whether acts were something that the president has discretion to do or not versus things that the president can't do. On that, Judge Henderson was saying he or she have to take care that the laws are discharged. So it would be awfully strange if they could just commit crimes themselves with impunity. All of this are, sensible questions to think about when you're trying to draw this line. And, it's been drawn in the civil context. Where somebody sues the president for conduct while the president is in office, but it's after. It's been drawn as a matter of criminal investigative process. In the Nixon case, you can get evidence and the like. Hasn't been drawn because they haven't had to for trials. It sure seems as if the right answer should be, if he shoots somebody on Fifth Avenue, clearly not official. It seems like anybody else. And if he does an official act, but it's a crime, it could be harder to prove. You can't do it while the president's in office. But once the president's in office, out of office, it seems like that's what democracies and places governed by the rule of law do, as opposed to autocracies where, presidents are strong arms and keep people from going after them. Anyway, Trump's going to lose. And so on substance, that matters. But we always with Trump play at two different levels, substance and timing. And how they decide it could determine if there's a remand, and if they then remand it to Judge Chutkan to apply, and Judge Chutkan applies it, well, would that give occasion to another round of appeals? And also, they could make it sort of more narrow and uncontroversial or less. And the less, the greater the possibility the Supreme Court just denies review, and that's the end of it. So, overall, satisfying, solid panel, good day for the rule of law, bad day for would-be autocrats. But whether it's a good day for the American people in the immediate quest to have Donald Trump be subject to the judgment of a jury as a felon or not before people vote whether to reelect him president. That, as you might say, the jury is out on. We'll know better when we get the opinion from the D.C. Circuit, which I think will be quite soon. Final point is when we do get it, we'll really look hard at what they do so far as the stay goes. They make a holding, and then if it's a normal garden variety case, they wait 30 days, and then they issue the mandate, which is the paper with the force of law. And then the person who loses can go to the full en banc court and ask them, and then 90 days to go to the Supreme Court. But they can cabin him in very, very much more than that. Say 5 days would be what the one of the parties have asked for, to 14 days, because it depends how they construct the stay. They could say, well, we'll stay our mandate. We won't issue it for, let's say, 5 days, but we will then, unless you've applied for cert, say. And then if that forces a quick cert, and then if the Supreme Court acts quickly, now the whole thing goes pretty quickly. So the other thing to look at when it does come out, and I think it will come out pretty soon, is what exactly it says at the very end as far as the stay goes. So you can expect Trump to lose. But it's not clear if how he'll lose might give him another opportunity for at least some kind of delay. And we'll want to look hard to see if how he loses forces his hand as far as pushing onward to the Supreme Court quickly, if that's where he wants to go. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.